We have breaking news out of Malaysia. Malaysian Prime Minister Muhyiddin Yassin has announced a nationwide lockdown to curb the spread of COVID-19 in the country. It will take effect from Wednesday until the end of the month. Now, this comes after the number of cases in Malaysia surged past 500.
Keutamaan kerajaan kita pada masa ini adalah untuk mencegah penularan baru wabak ini yang dibimbangi akan menyakiti lebih ramai rakyat. Situasi semasa wabak ini memerlukan tindakan
Hello everyone. Hello. How's life in quarantine?
Everything's good, I guess.
So far, for me also so good.
Okay, please be safe and avoid going out because you know right now COVID-19 viruses have spread very widely. So stay safe, everyone.
Okay, so now we will begin our arbitration session now. Are you guys ready?
Yes.
Okay.
Yes, I'm ready.
Okay, so good afternoon everyone. We are gathered here today to resolve the dispute between Danielli and OFFICINE MECCHANICHE SpA as the claimant and Sultan HRC SDN BHD as the respondent regarding the arbitral award and the subsequent issues. Before we proceed, allow us to briefly introduce ourselves. I am Fatin Husna. I have a law degree from USIM. I am duly accredited by the Construction Industry Arbitration Council, CIAC, as one of its arbitrator. I have done a specialization in the general contracts, and I have served 6 till 10 times as an arbitrator prior to this dispute. I am not a judge, but my decision will be legally binding upon the parties. Now I ask Ms. Iman to introduce herself.
Okay, thank you, Ms. Fatih Husna. My name is Nur Iman, and you can call me Miss Iman. And I am the co-arbitrator in this session. I have a law degree from USIM, same as Ms. Fatih Husna, and also accredited by International Center for Alternative Dispute Resolution, ICADR, as one of its arbitrators. I also have done a specialization in the construction contracts, and I have served 11 to 15 times as an arbitrator prior to this dispute. As mentioned by Ms. Fatin Husna, both of us are not judges, but our decision in this session will be legally binding upon both parties. Then we will hear both sides of the story, and we will be making a decision soon at this hearing. Does everyone understand?
Yes. Yes, I do.
Okay. Before we begin, we as arbitrators will take an oath as arbitrator in this session.
Okay. We, as an arbitrator selected to hear this matter, solemnly swear or affirm our duty under the Arbitration Act, Code of Ethics, or for arbitrators in commercial disputes to keep confidential all matters related to the arbitration proceeding and decision, including but not limited to any information, documents, evidence, or testimony presented, and that our duty is continuous and does not cease at the conclusion of the arbitration or upon our withdrawal as an arbitrator. We solemnly swear or affirm that we are not an employer of, employed by, or related by blood or marriage to any of the parties or witnesses whose names have been disclosed to us. Okay, next, we will start off with the parties doing the oath. Raise all your right hand now, please.
Okay, everyone follow me. I swear.
I swear.
I will tell the truth.
I will tell the truth.
I will tell the truth.
The whole truth and nothing but the truth.
The whole truth and nothing but the
The whole
truth.
truth and nothing but the truth.
Okay, thank you everyone. Now, I wish to lay out the procedures of the proceeding. As decided, we will have 4 sittings. For the first sitting, we will allow the parties to state the introductory of facts of the dispute, and the parties will be allowed to make their opening statements. In the second sitting, the parties will be allowed to present the evidence and bring their witnesses. Then, in the third sitting, there will be hearing and submission of any additional documents required for the matter. Last will be the final hearing, where the arbitrators, after considering all the statement and evidence, will be passing the award.
Before we proceed today, I would like to stress the impartiality and independence of this arbitration proceeding. We have already stated in our disclosure reports, which I believe the parties have already furnished with our background, our personal qualifications, financial and other personal interests, which we believe will not in any way affect our impartiality, and that we don't have any financial, fiduciary or other interests in this session or case to be decided or in the result of this proceeding, or has any personal bias which might prejudice the right of any party to a fair and impartial award. As appointed arbitrators by the parties, our role here is to carefully examine the evidence and arguments presented, and we will arrive at a fair resolution. And as agreed, we will conduct the arbitration hearing with mutual respect and allow each party an equal opportunity to present their case. For today, we are here to address the dispute between DANIELI and OFFICINE MECCHANICHE SpA as the claimant and Southern HRC SDN BHD as the respondent regarding the arbitral award and the subsequent issues. We will now start first with opening statements. Claimants, DANIELI's counsel, you may begin.
Thank you, Your Honor. As the counsel representing the claimant in dispute, I would like to provide an overview of the circumstances surrounding this matter. My client, DANIELI, is an Italian company specialized in manufactures steel making plants that build a plant in Penang for Southern HRC. And my client and the respondent had entered into a contract in 2011, whereby the claimant would erect a plant in Praia for the respondent to produce hot rolled coils. They had also entered into a service agreement in 2014, and the dispute then arose between them, and my client issued a request for arbitration, claiming sum owed by the respondent on the basis of an unlawful termination by the respondent. The respondent issued for rescission of the contract and service agreement, as well as damages for misrepresentation. And the arbitral tribunal decided that my client must pay damages to Southern HRC, and in return, Southern HRC was to transfer the title of the Penang plant to DANIELI. DANIELI seek access to inspect the plant before making the payment, but Southern HRC has denied this access. Therefore, we are here to seek a declaration that DANIELI is entitled to inspect the steel plant for the production of hot rolled coils plant and additional equipment located at 2723 Lorong Perusahaan 12 Praia Industrial Estate, Praia 13600, Pulau Pinang, Malaysia, for the purposes of inspection and ascertaining the existence, status, and condition of the same, and to enter and access of the site for the aforesaid purpose.
Okay, thank you. Southern HRC counsel, you may present your opening statements now.
Okay, thank you, Your Honor. Southern HRC maintains that DANIELI must fulfill its obligation under the arbitral award and pay the damages before we grant access to the plant. We challenge the court's jurisdiction to determine this matter, as the court's sole power is to enforce
the arbitral award, not to provide any other relief. And we request that this action be struck out based on the strict application of Section 8 of the Arbitration Act 2005. That's all.
Okay, Danieli's counsel, please proceed with your argument.
Thank you, Your Honor. Your Honor, we argue that our request to inspect the plan is reasonable and necessary to ensure the proper execution of the arbitral award. Without inspection, Danieli cannot verify the condition of the plan, which affect the transfer of the title. We are not seeking the undermining of the arbitral award, but rather to facilitate its proper implementation. And my client have a genuine to have their right, and that it is essential for them to inspect the plan so as to verify the condition before making any payment of the award sum.
Sultan HRC's counsel, your response?
Thank you, Your Honor. Your Honor, Section 8 of the Arbitration Act 2005 is clear, whereby it provides that no court shall intervene in matters governed by this Act, except where so provided in this Act, and the court's role is limited to the recognition and enforcement of the arbitral award, and any additional relief, such as allowing an inspection, falls outside the court's jurisdiction, and the award has been handed down, and the court cannot grant the relief that Danieli seeks.
Thank you for sharing your concern. Danieli's counsel, could you please elaborate more on your claim in regards to this dispute?
We believe that this court had the jurisdiction as the defendant is incorporated in Malaysia as well as the plan is situated in Malaysia. Also, we are merely seeking to ascertain if the plan being the subject matter of the award exists.
We would like to contend with this notion. The claimant could have applied during the arbitration proceedings to inspect the plant, but did not do so. And this court's sole power in respect of such an award is to enforce the same in accordance with the Arbitration Act 2005. And the award itself does not give rise to a cause of action, and plaintiff's cause of action, the right to enforce the award. And since neither party has applied to enforce the said award pursuant to Section 38 of the Arbitration Act 2005, then pursuant to the provisions of the Arbitration Act, this court has no jurisdiction to determine and grant the relief.
Okay, we understand both parties' position. We encourage you to consider a middle ground that would be in your best interest. Counsel for Danieli and Sultan HRC Counsel, we empathize with your situation. I would like to thank all of you for your participation. The arbitration hearing is now concluded. We will review the evidence, testimony, and argument presented today, and our decision will be communicated to both parties on the final hearing by 5th July 2021.
The session has now ended. Good morning, everyone. In today's session, dated 5th July 2021 at 9:00 a.m. in the morning, we gathered here today for our final hearing of the case involving Danieli and OFFICINE MECCHANICHE SpA as the claimant and Sultan HRC SDN BHD as the respondent.
Okay, after careful consideration of the evidence, testimonies, and arguments presented by both parties, Ms. Iman and I have reached a decision in this matter. We appreciate the efforts and cooperation shown by both parties throughout this session, this arbitration process. It is encouraging to see both parties willing to reach a resolution.
Based on our evaluation, we find that Arbitration Act 2005 explicitly limits the court's intervention to the recognition and enforcement of arbitral awards. Therefore, the court does not have any jurisdiction to grant any other relief in respect of a foreign award. The application by Southern HRC to strike out the action is upheld.
As seen earlier, with the 2011 amendments, Arbitration Act 2005 clearly also has application and makes provision for assistance, supervision or enforcement of an international arbitration where the seat is outside Malaysia, such as in Section 10, Clause 4 and 11, Clause 3. In this regard, a pursuit of Section 11 and in particular Section 11, Clause 3 especially provide that a party may, before or during arbitral proceeding, apply to a high court for any interim measure in respect of an international arbitration where the seat is not Malaysia.
As such, we find merit in the respondent's contention that it was clearly open to the claimant to have made an application for an interim measure or for inspection of the plant before or during the arbitral proceedings. The claimant, however, clearly did not do so and contend that they could not do so as the transfer of the plant was not a relief sought. Such contention finds no favour with us, as bearing in mind that the respondent herein was seeking rescission in the arbitration, and such the possibility of such being ordered was surely within the parties' contemplation.
Having produced the arbitral award, it was quite clear that the plaintiff had made submission on the issue of the return of the plant, which they contended before the arbitration tribunal was most likely to be in a state of utter disrepair, and that the contract price must be adjusted to take into account the diminution in value of the plant by reason of the same lying idle for 3 years after the termination. It is to be noted that the provision of such interim measure may only be applied for before or during the arbitral proceeding. It cannot be contended that the courts have wider power of intervention upon conclusion of such arbitral proceeding. The action by Danielli is struck out. The court's facilitation is limited to the recognition and enforcement of the arbitral award. No further declaration will be made. This conclude the proceeding. Thank you, counsel, for your arguments. The court rule is clear in this matter. We hope that both parties will now proceed with the recognition and enforcement of the arbitral award as stipulated.
Thank you, Your Honor.
Thank you very much, Your Honor.
Thank you to both parties. This session is adjourned.
Okay, that's conclude our session for today. Okay, everyone, stay safe and don't forget to always wear your mask and always wash your hands. Miss Iman, do you have anything to say?
Same as Miss Fatin Husna, please stay safe. Please stay indoors and keep being healthy and safe. Thank you.
Thank you.
Thank you. Stay safe too.
Thank you.